May it please the Court, my name is Slade, initials SS, appearing for the defendant, instructed by legal aid solicitors. Your Honour, my first submission to the Court is that the evidence should be excluded as there is tenuous ground for holding it technically admissible. It would be gravely prejudicial to the defendant and it should be excluded as per the fairness discretion set out in Christie. The Court may also exclude unfair evidence under Section 130 of the Evidence Act. One of the two conditions that must be met to exercise the fairness discretion is to establish that the evidence is slight or unsubstantial. The responses made by the accused were a result of gratuitous concurrence. The power dynamic between the accused, who is a child and Indigenous, in a position of powerlessness, and that of multiple police is a significant disparity. The evidence is unsubstantiated as the accused was merely agreeing with whatever was put to him. Direct questioning techniques used by the police are culturally inappropriate as there is no indication the accused understood what he was being asked nor believed in his answer. In the case, the Queen of Ngawali, an Indigenous woman, was charged with murder. The police failed to provide reasonable facilities to contact a friend or relative, as well as make sure the suspect understood the caution. The police also asked leading questions. The admissions was excluded on the grounds of being them so unreliable as to amount to unfairness. The Ngawali case is similar to the current case because the accused was also deprived of contacting someone to be his support person. Further, the accused was never cautioned. The police also asked leading questions when they drove by the 8 properties and asked if he broke into them. However, the accused in this case is a child and therefore especially vulnerable. The circumstances of the questions and interview were inappropriate as the accused was not cautioned, nor had the appropriate support person present, nor given the opportunity to communicate with a friend, relative or lawyer. The fact that the accused was never cautioned during his dealings with the police furthers the assertion that the accused did not comprehend what he was agreeing to, and this lack of comprehension means the admissions were not freely given. The accused is a special witness as per Section 21A of the Queensland Evidence Act, as he is under 16 years old. Under Section 421 of the Police Powers and Responsibilities Act, a child has the right to speak to a support person of their choice, and this person should be present during questioning. This further puts the accused at a disadvantage during questioning. The second condition to be met is that the evidence, if it were admitted, would have a substantial prejudicial effect on the accused. If admitted, the jury would very likely give the evidence more weight than deserved. A statement in which the accused appears to confess to crimes would greatly bias the jury and make them believe he is guilty. The Queen and Lee held that a confession or incriminating statement made in the circumstances of improper police conduct would be unfair to the accused to admit. As per the balancing exercise set out in the Queen and Hasler, the probative value of the confession by Darren is outweighed by the very high prejudicial effect that it would have if admitted. Second, the evidence should be excluded on the basis of public policy discretion. Regarding the first step of the multifactorial test set out in Bunning and Cross, at the very least, the breaches in question were reckless, if not major systemic or deliberate breaches. This is indicated by the number of breaches, the seriousness of those breaches, and that in the circumstances, the police could have easily complied with their responsibilities. This weighs in favour of excluding the evidence. The second step of the test stipulates that if it appears to be a deliberate breach, the court should not consider the cogency of the evidence unless it is essential to the Crown's case. If the court accepts that the breach was deliberate, then establishing whether the evidence is essential to the Crown's case is the next task. As the identity of the person who actually committed the break and enter and stealing cannot be established apart from Darren's admissions, it would be considered essential to the Crown's case. Following this, the cogency of the evidence must then be considered. The evidence has a low probative value due to the circumstances in which he was questioned and the occurrence of gratuitous concurrence. This too supports the notion that the evidence should be excluded. The third step addresses whether the breaches were a genuine response to extenuating circumstances. There is no evidence on the facts that indicate that any of the multiple breaches were a response to extenuating circumstances, and this further weighs in favour of the evidence being excluded. The fourth step considers the gravity of the charges, which in this case is breaking and entering and stealing. These crimes are neither violent nor heinous, and this further weighs in support of excluding the evidence. Step 5 relates to whether there were breaches, deliberate or not, of the Police Powers and Responsibilities Act. These breaches include the right to communicate with a friend, relative or lawyer under Section 418, questioning of an Aboriginal or Torres Strait Islander under Section 420, questioning of children under Section 421, and not giving the appropriate cautions under Section 431. The multifactorial test considers those factors on the balance of probabilities whether the evidence should be excluded. All 5 factors of the multifactorial test support the evidence being excluded, and therefore the court should exercise its discretion to remove the evidence. To admit evidence that has been obtained illegally by police, whose role it is to enforce the law, undermines the whole legal system. For the foregoing reasons, I respectfully request that the court find in favour of the defendant and exercise judicial discretion in excluding the confession evidence on fairness and public policy discretion grounds.